Everyone, now we will discuss on Supreme Court decision dated 7th May 2025 regarding limitation under section 61(2) of Insolvency and Bankruptcy Code. Because no delay beyond 45 days in IBC appeals under section 61 subsection 2. This is what the Supreme Court ruling. Welcome back to our Legal Insight series. In today's video, we break down a landmark ruling by Honorable Supreme Court of India delivered on 7th May 2025. This decision reaffirms a critical timeline under IBC, the 45-day limit for appeal to NCLAT. Let's understand what the court said, why it matters, and what this means for resolution applicants, investors, and litigants. Under section 61, subsection 2 of IBC, it says 30 days plus 15 days, maximum 15 days, that is condonable. So total 45 days. So under section 61, subsection 2 of IBC, an appeal against an NCLAT order must be filed within 30 days. Then the NCLAT can condone further delay of only 15 days. So bringing the total maximum of 45 days. So this limit is mandatory and non-negotiable. But what happens if someone files after 45 days? This is the question. This issue came to the forefront in case involving Rohit Ferro-Tech Limited. The NCLT approved a resolution plan on 7th April 2022. So a former minority shareholder filed an appeal before NCLAT on 23rd May 2022. So electronically filed on 23rd and physically filed on 24th. After the 45-day window closed on 22nd. So 45 days is closed on 22nd May. He filed electronically on 23rd May and physically on 24th May. This is a fact. So NCLAT still condoned this delay, but successful resolution applicant challenged this, citing strict statutory timeline. Supreme Court's analysis was the Bench of Justice J.B, Pardiwala and Justice R. Mahadevan set aside the NCLAT's decision. The court held that NCLAT has no jurisdiction to condone delay beyond 45 days under section 61 subsection 2. Section 4 of the Limitation Act, which allows filing on the next working day if the court is closed. This applies only to the initial limitation period, not to condonable extension. So the key quotes from the judgment was the court noted that the NCLT order was available via stock exchange disclosure. It is available in the public domain. The clock started ticking from 7/4/2022. Since the appeal was filed after 45 days, so it is a time bar. So legal precedent and provisions considered, the court referred to important precedents. Nagarajan versus SK Ispat. Limitation start from order date, not receipt. This was the judgment in the matter of V. Nagarajan versus SK Ispat. And another judgment, strict interpretation of limitation in the matter of Sagufa Ahmad versus Upper Assam Plywood. And section 12, subsection 2 of the Limitation Act allows exclusion of time to get certified copy if produced diligently. So the court also analyzed NCLAT Rule 3 and stressed that equitable considerations cannot override legislative mandates. So the final judgment, the Supreme Court declared that the NCLAT's order as ultra-virus. It allowed the appeal, closed all miscellaneous applications, and made no order on costs. So the appeal was allowed. Delayed for beyond 45 days, not condonable. Section 61, subsection 2 is mandatory. Time starts from order date. So the conclusion and takeaways with these judgments, this ruling is a reminder that IBC timelines are sacrosanct for all stakeholders. Whatever you are, a resolution applicant or a shareholder or legal advisor, keep in mind beyond 45 days, there is no appeal. So plan, act, and file accordingly. If you found this video helpful, give it a thumbs up, share with your legal community, and don't forget to subscribe RR Corporates and RR Legal Talks. We have 2 channels, RR Corporates and RR Legal Talks. Thank you.